This is Michael Cowen, and welcome to Trial Lawyer Nation.
You are the leader in the courtroom, and you want the jury to be looking to you for the answers.
When you figure out your theory, never deviate.
You want the facts to be consistent, complete, and credible.
The defense has no problem running out the clock. Delay is the friend of the defense.
It's tough to grow a firm by trying to hold on and micromanage.
You've got to front load a simple structure for jurors to be able to hold on to.
What types of creative things can we do as lawyers, even though we don't have a trial setting?
Whatever you've got to do to make it real, you've got to do to make it real. But the person who needs convincing is you.
Welcome to the award-winning podcast, Trial Lawyer Nation, your source to win bigger verdicts, get more cases, and manage your law firm. And now, here's your host, noteworthy author, sought-after speaker, and renowned trial lawyer, Michael Cowen.
Trial Lawyer Nation is brought to you by LawPods. LawPods is the company that produces these podcasts. They make my life so easy. All I have to do is show up and talk, and they do all the recording, making sure it sounds good, the editing, the putting out clips for social media. If you are thinking about doing your own podcast, I highly recommend LawPods. We're going to start a new feature on this podcast. It's Ask Michael and Malorie Anything. If you have anything you'd like to ask either Malorie or me, we're going to start doing an episode every couple months where we're going to answer your questions. So just send them in to me at michael@cowenlaw.com, and Malorie and I will answer them. Anything from, legal strategy, marketing management, anything else in life you want to talk about, we'll be glad to talk about it with you. Again, Ask Michael and Malorie Anything. Just send us an email. We'll be glad to answer your questions. Welcome to today's Trial Lawyer Nation. I am joined by my partner, Malorie Peacock. It's always a joy to be with Malorie. How are you doing today?
I'm doing okay. I'm losing my voice a little bit, so you might not hear from me as much this episode.
Okay, well, I try not to dominate the conversation, but I'm very capable of it. So we're going to do a new feature. We've talked about this before. We're going to do Ask Malorie and Michael Anything. And some of y'all were nice enough to send in questions, and we're going to do our best to answer them. Okay, Malorie, what's our first question, and who's it from?
So today we got a question from Riley, and Riley says, how would you plot out your career if you want to do PI and are starting from day one? Would you start your own firm or start working at a firm to build your way up? How would you do it?
I would definitely start at a firm. And I understand that people have succeeded both ways. I think, I ended up with my own firm way sooner than I wanted to. I think I was between 3 and 4 years of practice, and my boss kind of quit on me, and I ended up with a firm. And I think I've had so many struggles earlier in my career from not having a good mentor, not having guidance, not having adequate capital. So, there's pluses and minuses in both. I mean, if you're a real hustler and you think you can go out there and convince people to give you cases and, settle the ones you can settle, co-counsel refer out the ones that are going to be too big. I think you can make it working for someone else, but how do you market? I mean, it's such a competitive market to get personal injury cases. You can't do the traditional, unless your parents are millionaires, you won the lottery, you can't do the traditional advertising. Spending a little bit of money on internet marketing when your competitors are spending hundreds of thousands, if not millions of dollars, and have really sophisticated marketers working for them is probably not going to get you a lot of cases. So I think it's really tough. And then how do you develop your skills? I mean, yes, you can go to seminars, you can go to conferences, but, without a good network of someone to give you guidance on your cases, I think there's you don't know what you don't know. And I think there's a lot of traps you can fall into. So I would really recommend, if you want to do PI from day one, talking to PI lawyers, try to get a job with a personal injury lawyer while you're still in law school, and maybe they'll like you and hire you. I know a lot of PI lawyers aren't hiring while law school. The other traditional one is, go work on the defense side for a few years to get experience and then switch over. I didn't do that. A lot of people do. And that's another traditional path. But most people I know that started their own firm, they just were either super entrepreneurial and just wanted to do it, or they really didn't have a choice because they wanted to do PI and there were no PI firms hiring. In that case, I think you really have to think about, how am I going to get cases, and then just be really realistic. Like, what can I afford to do myself, and when do I need to bring in help? And if you have a good case, you will find help.
Yeah, I think too that running a firm is also running a business. And if you don't have any kind of business experience, you need to either get that somewhere or take some courses or something if you're going to start out on your own, because I think it's a mistake to treat your firm as just, I'm a lawyer and I'm just going to go do lawyer stuff. I mean, there's a lot of business pieces to it that you can learn by starting from day one at a firm instead of trying to do it by yourself if you don't have any business background.
Yeah, I think that's a good point. I mean, I had 20 years ago, had a partnership breakup. And one of the big reasons is we had settled a couple of really big cases, big at the time, like, a little over $1 million each. And I said, we got to put all the money back in these other cases. We can't take draws. I was very aggressive on that, on trying to build the business, but wasn't necessarily building a profitable business. And, I think my ex had some points there. I think that we both, I think, had, as in most cases, we both had points. But I think that, had I known how to run a business, I think we could have found a way to actually pay ourselves when we settled big cases.
So speaking of starting from day one, we actually have a question from a law student that submitted a question. Nydia said, I'm a third-year law student. What are the things I should be doing to get ready to practice law after graduation?
Well, a few things. I mean, one, make sure you pass your classes, obviously, and that you're going to take a bar review course, because if you don't get a law license, all this law school was for naught. So, make sure you take a bar review course. Don't work while you're taking the bar review course. Study hard for the bar. Make that your first priority. But while you're still in school, you want to start getting some kind of practical experience. So the two things I would recommend are either get a part-time job for a law firm. Don't worry about how much money you make. You want the experience and you want the connections. But really, applying it in real life. I mean, doing real research in a real case, drafting a motion. The other thing you might want to consider is doing a clinic where you actually get on your feet. A lot of states, you can get, a supervised bar card where you're allowed under supervision of the lawyer in a clinic to actually go and represent clients, to speak in court. That is also really good experience. But I really do recommend, especially if you want to, whatever type of law you want to do, if you can find that type of lawyer, whether it's personal injury, family, criminal, corporate, whatever it is, if you can find someone there and get some real life experience as to what you do, it really does give you a leg up.
And I think, too, that it helps you identify what kind of law you want to do. I mean, there's definitely things that I did in law school. I was of the idea in the mind that every single semester and every summer I would have a different clerkship or a different internship or a different job so that I could get as many experiences as I possibly could in the legal field. I didn't come from a family that had any lawyers in it, no extended family lawyers, no lawyers. So I had no idea what kind of law I wanted to practice. And getting all of those different experiences helped me kind of piece together what was it that I thought I would enjoy.
Yeah, I agree there. I worked for some plaintiffs' lawyers when I was in law school, 3 different ones. And I also did the big law summer clerkship. And I did not think I was going to go into personal injury law. Before I started law school, I was actually adamantly against being a personal injury lawyer. I was raised that we weren't good people and didn't believe in pain and suffering or non-economic damages. I've had a long journey on that. But I needed money and got some jobs for personal injury lawyers, and I really enjoyed it. And I think then when I went to big law and saw the contrast between what it's like to work at a big law firm, we have so many different layers of people and so much kind of useless make work for the purpose of billing, and working for big soulless corporations versus working for people and being efficient and being able to, just get things done. I realized I liked the personal injury a lot more, but I don't think I even would have considered it leaving big law, going to personal injury. I think I would have gone to like a more mid-sized firm if I left big law rather than going to personal injury. So I think that experience and getting those part-time jobs that frankly was just for beer money at first and some kind of experience really served me well. And then the connections. I mean, I've actually been, from my boss in Austin, my 3rd year, I've actually been local counsel for him. My boss, after my first summer, after my first year of law school, I've actually tried cases with him where he's brought me in. So, you sometimes that, 10, 20 years down the road, those connections are still there and it's really nice.
I do think too, the more that you can, even if you can't get clerkships or you can't get internships because school is taking too much of your time, and that is a real concern. I mean, you need to make sure that you're passing your classes and that you're getting what you need out of law school too. Going and sitting in the courthouse and watching real hearings and real trials, I think is so beneficial, especially if you want to be any kind of lawyer that has to go to the courthouse, right? So a family lawyer, criminal lawyer, a personal injury lawyer, contract dispute lawyer, businesses. But watching how it really plays out in the real world is, I think, something invaluable that you can do as a third-year law student and doesn't require a huge time commitment. You just pick a day, an afternoon where you don't have classes or a morning and go sit there and see what you see.
Absolutely. I think that also helps with anyone with imposter syndrome. If you're worried like you're not going to be good enough, go watch other people. They're not perfect. Go down to the courthouse. There's all different levels of lawyering, but people are making a living. I think it's a good thing to do.
So our next question comes from Jason. I want to be a trucking lawyer. Do I need to go to truck driving school and get my CDL to be a good trucking lawyer?
There are people that do that, and I can see some advantages. I think you definitely, if you want to be a trucking lawyer, you need to get inside a truck. You need to drive a truck. Seeing what it's really like, seeing the views you get from the cab, what it's like to turn, what it's like to back. I think that's all important. But there's ways to do that without actually getting your commercial driver's license. It takes a lot of time and a lot of practice to get your commercial driver's license. I think the time and skills commitment to actually drive a tractor trailer on public roads is greater than what you need to be an effective trucking lawyer. And I'll be honest, I don't have a CDL, and I think I do just fine trying trucking cases. But I have, there's a company called Legacy. They offer courses through ATAA, the Academy of Truck Accident Attorneys. They also offer courses on their own. If you contact them, they have a truck driving school for attorneys. So you do driving. You're not driving on public roads. You're driving in a parking lot, and then you're driving on a closed track so that you're not endangering people. You don't need to actually get your commercial driver's license. But they're teaching you the kind of skills you need and the situations that come up in cases. I think that's invaluable. I highly recommend it. I know the Academy of Truck Accident Attorneys, I just sent an email out today. We have a program coming up in May in Billings, Montana. I'm actually going to be teaching at that program on the legal end on how to take all the stuff you're learning from truck driving and apply that to your real cases. But I do highly recommend that. And if you want to get your CDL just because you're really passionate about it, I don't discourage it. But I also don't think it's necessary. So I don't think it should be like a roadblock. Well, I don't have time to get my CDL, so I can't do this. Like, yeah, you can. You just learn some basics.
Right,
or
right.
Even,
just like you don't need to be, you don't need to be a doctor to do a medical malpractice case, but you need to learn about it. You need to have someone teach you the ins and outs of it. You can't just, it is one of those things, there is a little bit of a learning curve. So you need to find a way to learn about it so that you can do it effectively.
Yeah, but I think the people saying you need to have a CDL, I think they're just, one, it's because they have one and they want to promote themselves. And nothing wrong with that. They did the work. But two, I think sometimes people that are in the club want to create a little bit of a barrier to entry. So it's like, well, no, you need to have I've heard people say you need to get your CDL and you need to hire these 5 experts and spend $100,000 in every case. And you need to do this. And basically they're trying to make people feel like they can't do it so that they have to refer it out. I find that if I just share things and tell the truth that I get enough work anyway.
Okay. Our next question comes from Natalie. I think my client has a brain injury, but there was no TBI, traumatic brain injury diagnosis at the hospital. What do I do?
Yeah, this is a really, really common situation. There's actually a study out there that they got people that were confirmed to have a traumatic brain injury and that also actually were hurt enough where they went to the emergency room, which doesn't even count all the other people that got traumatic brain injuries that didn't go to the emergency room. But the people that do go to the emergency room with a mild traumatic brain injury, 56% of them are not diagnosed with a concussion or a TBI in the ER. So, the one thing you need to do is just realize that the emergency room physician is looking at, does this person need to be admitted to the hospital? Do they have a brain bleed? Is there something that's really bad that's going to happen to them if we don't put them in the hospital? If not, we need to send them home so we can make room for the person that does need to get admitted. They're not spending the time to look for a concussion or a mild traumatic brain injury. They're looking for the big stuff. But the problem is some of these mild traumatic brain injuries end up lasting your life, and really they're not mild to you. They're only mild because you didn't lose consciousness for a long period of time when you initially got hurt, but they still can have a lifetime of impaired memory, impaired judgment, behavior problems. So just because they use the term mild doesn't mean they're mild. So what do you do? Well, first of all, you have to get a feel for it. So you kind of get a feel like someone's they seem to be out of it. They don't seem to be remembering things. They seem to be hard to deal with. So there's a couple, before you spend a lot of money, a couple of screening things I recommend is one, talk to people that have known them before they got hurt. Because sometimes like someone, they get let's say a frontal lobe injury, they lose control, they become a real jerk. And some people have just been a-holes their whole life. And that's just who they are, and it's got nothing to do with the wreck, and it didn't change. Some people, have memory issues before. Some people didn't have good memories, before the crash, and some people, they develop problems afterwards. So I think the first thing is, find out, is this something new? Because you didn't know them before. Then there's a nice assessment of things that you can ask for. I think one, and you can just Google this and get it, there's something called the Philadelphia Head Injury Questionnaire. And it's just got a whole list of questions you can ask. And, just kind of ask the ones you think might be relevant. And the more yeses you have there, the more likely someone might have a brain injury. It doesn't mean they have one. It just means, okay, it's worth looking at. And they may be like, do you forget things? Do you have trouble controlling your emotions? Change in smell, change in taste? There's just a whole litany of questions. So I think, if you suspected asking those questions, and if so, then you got to figure out, what do I do? Now, there's another challenge with traumatic brain injury is that while some traumatic brain injuries last forever, others heal in the first 4 to 6 months and heal 100%. And what you don't want to do, and I've done this before, is spend a bunch of money like doing a neuropsych exam, a 3T MRI, you get $40,000, $50,000 in a case, and then the client gets all the way better, which is wonderful for the client, but it means you're not going to get your money back, or you're going to waive your fees to try to get your expenses. So what I like to do is, make sure that the client gets those symptoms documented. So, when they go to the doctor, and they're going to, especially if they have memory problems, you probably need to make sure someone goes with them, that they write it down, that other person reminds them, because they will forget because they have a brain injury.
Right.
And also because the doctors kind of rush you through. And if you don't, especially after the first visit, they're just looking at what they've already seen. So you got to make sure that stuff gets documented in the records. If not, it'll look like they didn't really have it and it came up later. And, try to get them to someone that can at least diagnose and maybe give some initial treatment, a neurologist, maybe a neuropsychologist for like a mini exam, but don't do a full neuropsychological assessment and spend that kind of money. And then if after 6 months they still are having these problems, then more likely than not, they're not going to get all the way better if it lasts more than 6 months. So that's when I would really spend the money on getting a neuropsychological assessment, getting them into a brain injury program. You might want to put them into some kind of brain injury rehab in between to help see if they can get better and work with their doctor on that. But I think the big thing is make sure it gets documented early, and then once it's been more than 6 months, that's when you really can go nuts and do all the advanced imaging. In the meantime, though, I think the most important witnesses in a brain injury case are the people that knew the client before and after, and you really need to get those stories about how the client's different, what the life was like before, and how it's different now. Because without that, it's just these tests and other things just aren't that believable.
One of the things that we also do is get a client's past medical records to show that they never reported any kind of symptoms similar to this before, right? They never reported any kind of extreme headaches or depression or whatever the symptom is, memory issues before. That's really helpful too.
And there's some great tools out there. It's really scary, but there's some resources out there that with a release signed by your client, you can get all the doctors they've gone to for a period of time, what the diagnosis codes were, what medications they were prescribed. Because again, I don't think our clients are lying to us often, purposefully, but people do forget. And also, especially if they had a brain injury, they're even more likely to forget. And so I think it's helpful, before you spend a ton of money on working up a brain injury case, because that can cost. We've had multiple cases where we have multiple 6 figures in expenses on these TBI cases, trying to do everything we can to prove the case. I think it's worth it to figure out what kind of medical history the client had before, because the defense is going to get that anyway. So you need to know up front.
Right. And to Michael's point, our clients are not typically intentionally lying to us, but a lot of times, especially with symptoms like headache or depression or anxiety or something like that, what they have after the crash is a different kind of headache or a different kind of anxiety than they had before. And so just knowing that's in the record so that you can explain the difference, it is important, so that they're not going into a deposition thinking, well, I never had these kind of headaches before. But there's a reference to headaches, 5 years ago with their primary care doctor. And it was because of something completely unrelated, like dehydration or something. So our next question is, what are the top 3 things you look for in evaluating a personal injury case? This is a big one.
That is a big one, and I don't remember where I first heard this. I heard this early in my career. Is you think of it as like a 3-legged stool. So you need 3 things. You need liability, and what I really look for is aggravated liability. You need damages, and you need resources, insurance coverage, or some other resources to actually get paid. And they're all 3 are important. So the first thing we look at is liability. Now, first of all, you have to prove the defendant had some fault. No matter how bad the injuries are, the defendant wasn't at fault. But it shouldn't be like this theoretically, but also the more egregious the defendant's conduct, the more likely jurors are to follow the law and allow full damages. When people are just making a simple mistake, I think jurors often are hesitant to follow the law and allow full economic damages. And that's why you see some of these smaller, let's say like a car wreck case. It's like a low speed, an older lady just wasn't paying super duper attention and tapped somebody from behind. Now, it may have really caused injury, but it's just not that maddening. People aren't going to be that upset about it typically, as opposed to you have a company that knew that their product was dangerous. They knew people were getting killed, but they didn't want to stop making billions of dollars, so they kept it on the market and they hid the adverse effects. That is really, infuriating, and jurors are more likely to follow the law when they're mad at the defendant. So, you not only look at liability, but look at, do you have aggravated liability? So even if you don't have punitive damages, you still, I think, are more likely to get what you deserve in actual damages when you have aggravated liability. The second is damages. I mean, no matter how bad the liability is, you have to have some damages.
Right.
And so, I've got one case right now. I mean, the property damage is really good. What the defendant did was really bad, but it looks like the client's getting better. He's young. Looks like he's going to heal up pretty quick. We might not even file a lawsuit on that case because he's healing so quickly. I just had a meeting on that earlier this morning. And without the damages, I mean, you can only do so much with the case. Third is insurance coverage. We've all seen cases, a drunk driver with no insurance, kills a family of 4 or puts someone in a wheelchair. You have damages, you have aggravated liability, but there's nothing to collect. And, you can spend all the time in the world working on such a case. You're not going to make any money. And, you can go take what I think some people call a glory verdict, which is you can go, well, let's go try this case and get a big verdict and teach them a lesson. And, I don't necessarily say there's anything wrong with that, except that when I've done it, my client at the end of the day, no matter how many times you tell them, like, look, this is not going to be enforceable, we're just doing this to teach them a lesson, they're like, well, where's my money? Once they get that judgment, they expect to get paid, and then they've gone through the whole thing, and then they get mad at you because, well, I went through all this and now I'm not getting anything. Yeah, I told you that. or there's only, $30,000 or $25,000 insurance policy. It's like, well, I told you that from the beginning. But, so I'm really hesitant to do that now unless it's like the client really, really wants to do it and we've really talked about it. But that, again, I'm not criticizing people that do that, but I do think just be prepared for an unhappy client to do a bunch of work, not get paid, and have an unhappy client if you do that.
Each year, the law firm of Cowen Rodriguez Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and commercial vehicle cases. If you have an injury case involving death or catastrophic injuries and would like to partner with our firm, please contact us by calling 210-941-1301 to discuss the case in detail and see where we can add value in a partnership. And now, back to the show.
Right. And I think when you're evaluating a personal injury case, it obviously depends very much on the type of firm that you have. So there's firms, and, Michael, I think you're partners with one in New Mexico that takes everything that walks in the door and then investigates it later and figures out if, is this a case that we can resolve or not, or is it a case we should stay in or not? But everything that comes in the door, you sign up. And that's a different model for business than what we have here at Cowen Rodriguez Peacock.
Yeah, I would say everything, but a lot. Yeah. If it looks like there's liability and there's some kind of damages, we sign it up. Yeah, there. Right. It's a different business model. It's a different firm, and there's nothing wrong with that. I mean, those people need representation too, but you do have to look at what you're looking for. Yeah, what you want to be as a firm.
Right.
And I was talking to a good friend in Chicago day before yesterday, and he only takes cases that are worth $1 million or more. He will not take a $750,000, $800,000 case.
Yeah.
I told him to send it to me, but we will. But and good for him. I mean, I'm glad that he can do that. I mean, we have very different setups, very different. I've got 10 lawyers to feed, and we got to get work in. Whereas other people, that's their model. But earlier in my career, I was thrilled to get a chiropractor only case because I needed work. So it just depends on where you are in your career. But still, when you're evaluating it, those are the three things you look at.
Right. Okay. So the next question is, I'm about to file suit in a federal district court where I have never practiced before. What are the things I should do to avoid falling into procedural traps?
This is a big one. And this is something that we end up doing quite often is we're getting brought into cases in other courts. So one thing you want, if you're not admitted in that court, you need to get pro hoc featured anyway. So you want to get local counsel and try to find local counsel that has got some experience in that court with that judge if you can. Now, the problem is, I know for us, a lot of times we're being brought in by a lawyer that if they had experience practicing in that federal court, they probably wouldn't need us. So a lot of times the lawyer bringing us in, while they may be admitted, does not practice a lot in that court. So I think, luckily a lot of stuff is on the web now. So some of the things I recommend is, you want to look at the district's local rules. And it's a pain in the butt, but, to get admitted in federal court or even get pro hoc featured, you're certifying that you read the local rules. And, different courts have different requirements that are just in the local rules. They have motion response deadlines. So, in the Southern District of Texas, you have 21 days to respond to a motion. And if you don't respond within 21 days, it's presumed to be unopposed and it's going to be automatically granted. In the Western District of Texas, that's 7 days to respond to a non-dispositive motion, 14 for a dispositive, or it's going to be granted. I think it's 15 in New Mexico federal court. So, you have to know that there's these different things for different days. Other courts have certain requirements in their expert disclosures. So normally Rule 26 sets out what we need to do for our initial disclosures in federal court. But in the District of New Mexico, they've added another disclosure. You have to list the doctors your clients have seen for a certain period of time and give a medical authorization or give some kind of briefing as to why you're not giving a medical authorization for those doctors. That's something you have to do automatically. There's other courts have mandatory disclosure that you have to right away disclose all the evidence some is just the ones you're going to use, some is it's just anything relevant to the case. You just have to do mandatory disclosure, even if it's not good for you. You need to know that because if you're in the Eastern District of Texas has some pretty aggressive, in the past, at least mandatory disclosure judges. And if you don't do that, you don't want to be getting compelled when the judge thinks you should have just given it automatically. And that can be a big problem. But on top of the local rules, then a lot of judges have chamber rules. So you need to go look to see if the judge has their own specific procedures on how they want things done, how they want things filed, whether you can just e-file or you have to also deliver a copy to the judge. Especially as you're coming up for trial, a lot of them have some very particular ways they want things done. And you just have to note all those things. You really have to go through and jot down what you have and then make sure it all gets put into your case management system or your calendar or however you keep track of deadlines, that you have the reminders to make sure you're not going to blow any of these deadlines. And then finally, when you know what judge you have, if you can find someone that's tried a case in that court and just talk to them about what are the pitfalls, because there's so many, I hate to quote Donald Rumsfeld, but there was the unknown unknowns. It's the things you don't know that you don't know. The things you have to do, local procedures, you don't even know that they're there. You don't even think to look for them, and then they pop you. And that's really scary. And you've dealt with that before, Mallorie.
Yeah. I think that's the scariest thing about practicing in courts you've never practiced before is it doesn't even occur to you to look, right? There's things that are different about the law in other jurisdictions. I practice primarily in Texas, but I have a lot of cases out of state too. So it's surprising when you practice out of state or in various federal courts how different the rules actually are for different things: discovery, depositions, trial stuff. It's can be surprising sometimes.
Absolutely.
But one of the things that is also hard is that if you've always practiced in that jurisdiction, it's not weird to you, right? It's just the way that it is, right?
And you don't see a need to warn your co-counsel about it because it's just that's how we do things. I thought that's how you do. They don't know that you do it differently otherwise. So I think having that conversation, is really important.
And I think too, you just have to go into it realizing you're not going to know everything about everything and just be keeping a lookout for things that might pop up or, if opposing counsel is doing something, trying to figure out why they're doing it, right? That's one of the things that I do when I'm in other jurisdictions. If opposing counsel is suddenly doing something that looks weird or different, I immediately try to figure out why they're doing it, because maybe I should be doing it too, right? So,
and if you do blow one of those internal deadlines, or something you didn't know that you didn't, you find out later, just very quickly move for leave to fix it. And I'll give an example. There was some of the federal courts in New Mexico say that a treating doctor has to give a written report if they're going to testify as to causation, that's saying the crash caused injury, even if it's mentioned in the medical records. We didn't know that on a case, and we were at a mediation with the magistrate. The magistrate mentioned it, and then we had named the doctor, we'd produced the medical records, we had said the doctor was going to do this, but we didn't have a written report from the doctor. So we very promptly filed a motion for leave to supplement with a written report, and the court granted it, and now we're fine. But, had we just pretended, let's just try to sell the case and hope we get away with it, that wouldn't have worked.
Okay. This one, I think both of you and I have a lot of experience with. The next question is, I spent a bunch of money on a demonstrative exhibit, but I'm not sure how good it is. How do I figure out if it will work? And what do I do if I spend a bunch of money on it and it doesn't work?
Yeah, that's really important. And we've done that. We've spent lots of money on animations and other exhibits and ended up not using them. In fact, I think when we were trying our forklift product case, we built 2 full-size forklifts, one the actual design, one the safer alternative design, and had them there and had all these hearings and all this fight about whether we can use them or not. And then, one, they didn't quite fit through the courtroom door. But the other thing is we realized that we were better off not using them for various reasons. And I'm glad we didn't. So what do you do to figure it out? I mean, one, you need to figure out what is the point of the exhibit. The exhibit shouldn't be there just to be pretty, just to be nice, just to show how badass you are. But the exhibit is supposed to prove a point. So if it's let's say an injury illustration, when you look at that, what is the first thing you think? Are you thinking how badly hurt this person was? Are you thinking that this really, this would be painful, this would be permanent? Are you thinking like, well, this is an interesting surgery, but I don't know what it has to do with anything? Same for liability. If you're looking at a liability exhibit, are you thinking when you see it, the defendant's clearly at fault? Because if not, then you might not want to show it. So what's the point of view? What does it really show? But, we know our own cases. We believe our own BS. It's really important to show it to other people. I mean, ideally, you'd get a focus group or 2 and show it to a focus group. You can't always afford to do that. You don't always have time to do it, but that's the perfect one, is show it to a focus group, see what they think. If not, show it to other people around your office, show it to friends, show it to family members, spouses, kids, and see what they think. Make sure they're people that will actually give you honest feedback and not just say the right things to make you feel better. And from there, then you have to decide what to do. So if it doesn't work, you've got a couple of options. I mean, one is you sometimes just have to say, I'm going to scrap it. I mean, I spent the money, it didn't work. Just because you spent the money doesn't mean you should use the exhibit. If it doesn't help you, if it doesn't make you more likely to win the case, then you should not use the exhibit. Sometimes you can make changes. I mean, we had one, it was an animation we had done, and when we first used it, the jury thought the animation made our client more at fault, or the driver of our client's vehicle more at fault. And so when we, started doing it from other perspectives, from the defendant's driver's perspective instead of from like an overhead view, or our client's perspective, when we started showing, we learned we had to break it up and not just show it all the way through, but we had to preview, like show what the rules are and then highlight, hey, this sign comes up giving you a warning, this sign comes up giving you a warning, and learn how to sequence it and then test it again. And then we finally, I think after our 3rd or 4th try, found a way to make it work. But it took a lot of work to find, and I think it was worth it because I think that case ended up resolving really well. But I think it's because we had to learn how to tell the story in a persuasive way. And my initial idea didn't work. And then we had to keep working on it till it did. But then other times we spent a bunch of money, or the referring lawyer, like the case you and I almost tried that just resolved last week, the referring lawyer spent some money doing some animations that honestly we wouldn't have used.
No, yeah. And they were medical animations. And, and on that same case, I spent money doing an animation thinking it would be helpful for the liability story. And the animation just didn't prove the point I thought it proved. It didn't necessarily hurt the case, but it didn't really help the case either. It just wasn't moving the ball forward for anything. But I figured out that I could take screenshots or still images from the animation, and that was useful to me. So that's how I edited that to make it useful, even though that's not originally what I had thought I was going to use or what I was going to do. So once I saw the animation, I thought, well, this isn't, I don't know that it's that helpful to us, but the little screenshots were helpful. So I used that instead.
Yeah, and that's a case where our client was crossing, on the crosswalk with the green, and the defendant made a right turn anyway and ran her over. And the screenshot showing that she's very clearly visible. He tried to say, well, this was in my way, that was in my way. She shouldn't have gone without making sure that there wasn't something blocking my view, even though she had the green signal to cross. Showing that she was clearly in this view before we started was great, but the actual animation showing her get hit was not that effective.
Yeah. And I think over the years too, I think me and you have both kind of come to the same conclusion that generally animations of surgeries are not always super helpful, right? Like, and there's maybe a time and a place for it, but most of the time when we see animations of surgeries, they're either too gross, right? Like they're just over the top and it could make the jury feel like you're overdoing it, or they're not gross enough, right? They don't look serious enough, even though it was a very serious procedure. And so what point are you trying to make with the video as opposed to just having the doctor talk about the surgery or explain it with just still pictures or something like that? I mean, you have to ask yourself that question. What is the point I'm trying to make with this?
Yeah, I've learned over the years from trying. I used to do a lot more the medical illustrations on surgeries, and what I found out, if you make the case about the surgery, then you get the surgical cost from the jury.
Yeah.
If you make the case about the fact surgery is important, that your client hurt enough that they were willing to undergo a surgery, and the doctor thought they needed surgery, but the real damages are what is the effect on your client's life? What are things they can no longer do now that they could do before? What kind of treatment, what kind of vocational impairments are they going to have in the future? That's what the case is really about. And so when we focus so much on what the treatment was, it's like, okay, well, they had this treatment, we'll pay for the treatment. It's not really moving the ball forward and motivating the jury like we think it will. And I think a lot of it, we just see these things at seminars and they send us ads and they look cool, so we do them. But I don't know that they really lead to bigger verdicts as opposed to spending time with your clients, their friends and families, finding photos of them doing things they love doing, finding videos of them doing things they love doing. I think on that case, when I was preparing for trial with you, I mean, one of the things she said she did is she loved dancing, and there was a video of her dancing, at a wedding or quinceañera like a week or two before the crash, and that is a lot more effective to me than an animation of a surgery, even though she had some really big surgeries with plates and screws and broken bones and stuff. But the fact is, you can show like she really did do this. She had joy in her face. You could see her doing it. She didn't have any problems doing it. And now, I mean, and then the photo of the knee after the surgery with all the plates and screws and stuff in it. Those to me are so much more effective and free. I mean, we had to get the X-ray anyway, and I guess there's a little cost to get a copy of the film. The video the client already had, but I think they're a lot more effective than showing that there's a surgery she got while she was asleep.
Right. Yeah, I'm not. There's some very good lawyers that use real videos of surgeries. It's not for me, I will say. And the point that I'm making by saying that is that it's if your gut tells you don't like it, then you shouldn't use it, because then you're going to be defensive of it because you already don't like it. And the jury can tell if your questions seem defensive or they seem like you're trying to overdo it or prove something about it to them or to yourself. So if you don't like it immediately, you shouldn't use it.
And there's some suspicious jurors who think we're trying to gross them out to manipulate them, and you've got to watch that too.
Yeah. So our last question for this first Ask Michael and Malorie Anything. I hired an expert that everyone says is great, but after working with him, I'm starting to have some doubts. How do I figure out whether an expert is good or bad for my case?
Any experience with this, Malorie?
Yeah, I think we've had experience with this too.
Yeah, so be very... you need to ask for recommendations. I mean, networking is the best way to find experts, but you have to be very careful with the recommendations. And you have to think of a few things. One, consider the source. So what kind of lawyer is the person giving you recommendations? Is it somebody that actually tries cases and tries them successfully and is a master of this area of law? So let's say if it's a trucking case and Joe Freed or Michael Leeserman says this expert did great at trial, that carries a lot of credibility. If it's someone that I know has settled all their cases and hasn't tried a case in 10 years, I mean, the expert may have great technical knowledge, but I'm going to wonder about how this expert presents. Not that their advice is necessarily bad, but they've not been battle tested. And If it's someone that's not a true trucking, let's say I see experts that miss issues all the time. And because we're specialists in trucking, we kind of know what the issues are going to be. And, then we have to have a talk with the expert and then, oh yeah, I saw that. Well, if it's someone that's not a subject matter expert, let's say I was going to do like right now I'm doing a case where a stair wasn't properly maintained and a huge chunk of concrete falls 16 feet, hits a woman in the head. If my concrete expert doesn't know what he's doing, I wouldn't know.
Right.
And so if it's someone that's not a trucking expert and the person's saying, well, here are your theories of liability, and he's, oh, great, he's giving them to me, they may think he's good. I may look at the same expert and say, man, these 3 things are stupid. These are technical violations that didn't cause the crash, and he missed these other 5 things that are really important. So is the person recommending the expert really a true technical expert? And then I think the other thing is, will the expert work with you? Some of these experts, they get a big head. Maybe they were better before, but will they meet with you? Will they make sure that they can work with you to get what we call anchors, but like some kind of authoritative source to support their opinion, so it's not just them saying it? It not only makes them more persuasive with the jury, but it sure helps defeating a Daubert challenge when you have some kind of reliable basis for the authority instead of just, well, that's what we do in the industry. Sometimes that's all you can get, but it's better to have someone. But are they willing to work with you on that? Or do they have a huge ego? Will they make time to work with you? Will they make time to prepare? And then will they be nice? I mean, are they so defensive that they get to be jerks when they're giving their depositions or when they're testifying? Again, you have to go with your gut, go with your experience. And the other thing is, experts that were really good, they either get too busy and they get sloppy because they don't have time to prepare, or sometimes they just, as we age, we sometimes aren't as sharp as we used to be, or sometimes as we get more money, we're not as motivated as we used to be. And, so sometimes people that were great experts 10 or 15 years ago, either due to age or just due to they don't care as much anymore, or they just get cocky and don't prepare, they're no longer as good. And again, so if your expert ends up being bad for your case, if you have time, even if you spent money, dump him or dump her and get someone else. If you don't have time, you just got to do your best and try to make it work.
Yeah. Yeah. I mean, there is some time that, especially if it's an expert I've never worked before, that I spend at the beginning of a case interviewing them, right? Like a job interview, not a traditional job interview, but, what are your thoughts on me helping you create your PowerPoint for your trial testimony? Like, what are your thoughts on, sending me a draft report if you're allowed to send draft reports in your jurisdiction, and reviewing it together before we finalize it? What are your thoughts on, looking at literature and citing it in your report? I mean, things that are important to me, and get their feedback on it. And, I've found people to be very honest about those things, and we can still be friends, but you can't be my expert, right? And that's fine. And, if they're not the right expert for me, then I can say it nicely and just say, we've decided to go a different direction. But getting that information at the very beginning and doing like a little mini interview meeting with a new expert, with someone I've never worked with before, has helped me a lot avoid, experts that I wouldn't have liked working with, I think.
Yeah, I think it's one of the things we learned from working with a consultant named Rodney Jew. Is like, we're paying them cash, American money, checks, whatever. We are paying them U.S. currency. They need to do things in the way we want them done. Now, that doesn't mean we pick what their opinions are. Now, if the expert doesn't think the case is good, they don't think the case is good. They don't think there's medical causation. I respect that.
Right.
But if you do think the case is good, then you need to give me a report on the deadline when I need it, not when the court says it's, because I want to have time to read it first. And I don't want to be up till midnight or 4 a.m. reading it either. And I don't want to be all stressed out and having, I need you to be willing to support your opinions with authoritative literature, because that's what is required, and that's what's more persuasive. I want you to meet with me so we can practice, and we're not just winging it in court on a multi-million-dollar case. And if you're not willing to do that, and some people get an ego, I don't need to do this, and I've got plenty of business. That's fine. You can have plenty of business, but you can't have mine. And if you want to have my business and my money and my recommendations to my tribe, then you have to work with me, and you have to do things on time, and you have to meet with us, and you have to make sure your opinions are reliable, and you need to be nice, and you can't be an ass to my staff, and you can't be an ass to my clients. And, I think that's perfectly reasonable. I mean, we have the standards for our own employees. Why should we not have those standards for the experts and consultants we work with?
I also find that a lot of expert witnesses that I talk to are, desperate's not the right word, but love that kind of feedback from lawyers. They want feedback from you. I mean, they expect feedback from you. I mean, when they call you after the deposition and they say, how did I do? They don't really want you to just say, oh, it was fine, it's whatever, moving on, right? They want feedback and they want tips and they want to be better at being experts. And just like we want to be better at our jobs, right? We want constructive feedback and we want to work with people in a way that makes the case easier or better or the experience better. And they do too, most experts. And you can identify the ones that don't want to do that pretty quickly. But I think people, especially lawyers and young lawyers, are afraid to give feedback to the experts because they think, well, it's their expertise. I don't know, right? And I'm not the expert in this. I don't know. But you are the expert in trying cases and storytelling, which they are not. So it's a joint effort.
Yep. Well, thank you, everybody who sent in questions. This has been a lot of fun.
Yeah.
I'd like to do this again. So any listeners, if you have anything you'd ask, like ask Malorie, ask me, or ask both of us, please send the questions in. You can just email me at michael@cowenlaw.com, COWENLAW.com, and we will answer them on a future episode. So thanks, everyone, for tuning in to Trial Lawyer Nation.
Thank you for joining us on Trial Lawyer Nation. I hope you enjoyed our show. If you'd like to receive updates, insider information, and more from Trial Lawyer Nation, sign up for our mailing list at triallawyernation.com. You can also visit our episodes page on the website for show notes and direct links to any resources in this or any past episode. To help more attorneys find our podcast, please like, share, and subscribe to our podcast on any of our social media outlets. If you'd like access to exclusive, plaintiff lawyer-only content and live monthly discussions with me, send a request to join the Trial Lawyer Nation Insider Circle Facebook group. Thanks again for tuning in. I look forward to having you with us next time on Trial Lawyer Nation.
Each year, the law firm of Cowen, Rodriguez, Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and commercial vehicle cases. If you have an injury case involving death or catastrophic injuries and would like to partner with our firm, please contact us by calling 210-941-1301 to discuss the case in detail and see where we can add value in a partnership. This podcast has been hosted by Michael Cowen and is not intended to, nor does it create the attorney-client privilege between our host, guest, and any listener for any reason. Content from the podcast is not to be interpreted as legal advice. All thoughts and opinions expressed herein are only those from which they came.